Hi, my name is David Shapiro. I'm a San Diego-based criminal defense attorney, and today I'd like to discuss with you charges of allegedly violating a restraining order. There's a couple of ways you can wind up on the wrong end of a protective order here in California. The first would be if it is a civil harassment protective order. So two civilians, not necessarily in a domestic quote-unquote relationship, and someone goes to court, petitions the court for a protective order. It's granted after a hearing. The second one would be in a situation of a domestic violence civil protective order where there's no criminal court case, but it's just civilly, you go to civil court, there is a domestic related protective order against another party. And then what we see a lot as a criminal defense attorney, more often than not, is when you go to criminal court and there's a criminal protective order issued in favor of the alleged victim while the case is pending or after the case is over, for the period that you're on probation, or in some instances, on some offenses, even lasting longer than the period of probation. So, there's many different defenses to it. Violating the protective order, a lot of times people get in trouble when they're confronted by law enforcement and they're saying, this person said you did A, B, C, D, and E. No, all I did was go and talk to them. I didn't hit them. Okay, well, what have you done? You just corroborated and confirmed that you were there in violation of the restraining order if you were served with it. And if you were given information that says, hey, you can't be around this person within 100 feet of this person, whatever the specific terms of the protective order are. A lot of times these protective order cases, if you don't have any record, can be successfully negotiated, even if you're as guilty as the day is long under the law. But what you need to be aware of, and more importantly, I think what your attorney needs to be aware of, and not that many are, that I see for better or worse here in San Diego, is that if you're convicted of violating a domestic violence restraining order, even if there was never a court case, so say your ex-wife goes to civil court and gets a restraining order against you, never been arrested, never anything, you're then alleged of violating that domestic violence protective order. And if you're convicted in court of that, what are they going to do? They're going to put me on probation, big deal. I'll pay the fine, not a big deal. But what that requires under the law is that you have to do 52 weeks of domestic violence classes, even if convicted of a simple violating a restraining order for the first time. And a lot of times that's the worst sentence realistically you might be looking at if that's all your charges. But you want to make sure you hire an attorney to try and negotiate the case to try and resolve it for something that doesn't involve the burdensome aspect of 52 weeks of domestic violence classes just because you violated a protective order. If there's domestic violence allegations involved, if it's a realistic domestic violence case, that's one thing. But a lot of times good people wind up in a situation where they're accused of violating a protective order, and next thing you know, they have to do 52 weeks of classes, and if they don't do it, things start spiraling out of control. They wind up being landed in jail, additional charges come down the pipe, so on and so forth. So, even though at first glance it might not be the most serious of charges, these things can definitely spiral out of control. Make sure you first obey the protective order as best as you possibly can. Document any harassment from the other party trying to basically dupe you or induce you to violate the restraining order. And equally, if not more importantly, make sure you hire the right attorney who knows what he or she is doing, who has experience dealing with these types of cases.